right, counsel for Mr. Ford. Mr. Greenlee, is it?
Yes, sir.
Good morning to you, sir. How much time would you like to reserve for rebuttal? Is 5 minutes acceptable?
5 minutes is acceptable.
All right, sir, you're welcome to proceed.
Good morning, Your Honors, and may it please the Court. My name is Andrew Greenlee, and I'm here on behalf of the appellant, Mr. James Ford. Your Honors, the question at the heart of this appeal is whether an individual may be prosecuted and convicted for human trafficking when there is, in fact, no human and there is no trafficking that actually took place. We know from the Yates case that even when the conduct at issue can fit within a broadly worded definitional term in a statute, it can nevertheless not cover the conduct at issue. The Yates case dealt with Sarbanes-Oxley law, which is a record-keeping statute. The gentleman, the defendant in that case, was a commercial fisherman who had disposed of a fish.
Right, but counsel, we're not talking about fish versus paper here. We're talking about a crime involving a child and traveling to the location to meet the child, and the child just happened to be a law enforcement agent instead of the child.
That's correct, Your Honor.
And attempted human trafficking, do you dispute that's a crime? That is a potential issue?
No, that's correct.
Okay.
Attempted human trafficking is a crime. Our contention...
So the fact that he didn't get to complete the act, that should absolve him of human trafficking?
No, Your Honor. No, that's not our position at all. We don't dispute that there is an attempted... you can attempt to commit human trafficking. Let's say, for instance, he had attempted to overbear an individual's will, a minor's will, and serve as, for lack of a better term, the purveyor of her services on behalf of other people. In the same way that we view, like, let's think about it, take a step back, drug trafficking, right? The people who are the drug traffickers are the people who smuggle the drugs, the high-level dealers. We don't prosecute the people who are low-level purchasers of drugs as drug traffickers. So, again, in the normal parlance...
But they can be, in certain, depending on the facts, right?
If they're purchasing huge amounts, yes, the drug trafficking statute can apply to them. But low-level offenders who are purchasing minuscule amounts of drugs, we don't view them as traffickers. We don't treat them as traffickers. The law shouldn't treat them as traffickers. In much the same way, people who produce child pornography are treated differently under the law and more severely than people who have that contraband on their laptop, for instance. So again, these are distinctions that are germane to what's at issue here, because again, there is no evidence, and just to turn, because this is a case of statutory interpretation, to turn to the language of the statute, not only is the title of the statute, human trafficking, which we know from Dubin and the aggravated identity theft that was at issue there, we look to the actual title of the statute, human trafficking. What's the first sentence say? The legislature finds that human trafficking is a form of modern-day slavery. And then that paragraph, which is important, it goes on, victims of human trafficking are young children, teenagers, and adults. So we know this applies to adults as well. Thousands of victims are trafficked annually across international borders. So the movement of people is what this case concerns. The actual trafficking of people. It goes on. Many of these victims are trafficked into this state. So look at how this verb traffic is used here. I mean, if you take, well, let me just continue on. Victims of human trafficking also include citizens of the United States and those persons trafficked domestically within the borders of the United States. So this statute primarily is concerned with taking people against their will and moving them from place to place, using them, exploiting them for, and again, just reading from the statute, the legislature finds that victims of human trafficking are subjected to force, fraud, or coercion for the purpose of sexual exploitation or forced labor. There's also a provision in the statute that deals with branding. You brand someone. That's an enhancer under the statute. So these are kind of the class of actions, the classes of conduct that are at issue in human trafficking. We wouldn't, I don't think anybody here in this courtroom would say that a person who goes, for instance, in allegations against Robert Kraft, who goes to a massage parlor and gets a massage that's inappropriate has trafficked that individual. He's a consumer of the commercial sex trafficking. That is true, but he is not the trafficker. He is the one who is partaking in the trafficking, and that there are crimes that cover this type of conduct. In fact, what he was initially charged with, traveling to meet a minor. You know what? We don't dispute that the evidence was sufficient to convict him of that crime. But the crime of human trafficking, that's altogether a different kind of class of behavior that the statute is getting at. And we don't believe that he was guilty of that. And so again, we know from...
That's not what the Matos case says.
Yes, we think that that case is distinguishable on two bases. Number one, there was a continued course of conduct in Matos, I'm not sure how you pronounce it. So the individual actually went and met with the child. He could see the child with his own eyes, he could see that she was being exploited, and he kind of, on repeated occasions, he kind of wrapped himself up into that. He paid the money went to her handler, her pimp. So that is a different kind of class of cases because through a continued course of conduct, he engaged in human trafficking to the extent that he knew that the person was being trafficked. As opposed to here, and think about some of the text messages that were sent by my client. She said, "What do you want to do?" He said, "We don't have to do anything if you don't want to. We don't have to do anything. We can just smoke some weed and chill." So that's not the conduct that is indicative of trafficking that person. So again, as we say in the brief...
Bring $150 just to smoke weed and chill?
Look, I think that if it's traveling to meet a minor, the evidence was sufficient at trial to prove that. But again, we're dealing with trafficking here. And so if they wanted to write a freestanding prohibition against prostitution, which is already on the books, but if they wanted to include, the legislatures don't hide elephants in mouse holes, right? So if they wanted to make simple solicitation of prostitution the subject to these draconian penalties, and again, we know from Dubin that you look to the actual penalties that are at issue as context clues as to whether or not the conduct that's prescribed by the statute meets the conduct that has been proven at trial.
Well,
So-
this isn't even subject to the solicitation of prostitution because it's a minor.
Right.
Explicitly, that doesn't apply. So that's not what's at issue here. But was this argument that you're making now, was this argument made to the trial court?
The argument that I'm making now is, I think it was fairly preserved, Your Honor. Here's what he said. Counsel said, "Judge, I just don't see the human trafficking that was there. The guy's being told to show up at a certain location. He showed, he eventually shows up, but absolutely makes no act at that point to try to meet anybody." And then the state goes on in response, and this is, again, the whole point of preservation is to put the court on notice as to what the basis of the argument is. And so the state kind of provides additional context. Here's what the state says. "As for the human trafficking, there needs to be either the actual or attempted act of commercial sexual activity with the person believed to be the child." By the person believed by the defendant to be the child. Here we have testimony by numerous people saying that there were those text messages. He agreed to the $150 to engage in sexual activity with the person he believed was a child. So we do believe that human trafficking should go to the jury. So based on all that, the state is saying it's enough that he showed up and he wanted to pay money for a commercial sex act. That's enough to bring it within the ambit of the statute. And we think that reading is wildly overbroad. It would sweep in, there's nothing in the text of the statute, the definition of human trafficking, it makes no distinction by virtue of age. So
But that argument that now you're making today, that you just continued on from the state, none of that was argued to the trial judge.
No,
It was basically, they didn't meet the elements because there's absolutely no act at that point to try to meet anybody. That's
We're arguing that
the
there's
defense.
no trafficking.
Right, and then the state's saying, no, these are the elements, and this is what we've shown, which is a JOA argument, and now the end, and now you're making, again, the argument that you're making here today. But that argument that you just restated, you were not continuing on in the transcript, correct?
No,
That
well,
was an
I did-
argument you're making here. I just want to make sure that I understand.
Yes,
Okay.
Your Honor. That is the argument that we're making here in a nutshell is that there was no trafficking. That's what the argument that counsel said. I don't see human trafficking. There's no trafficking here. That's the argument that counsel advanced.
No, you're making the argument that it's technically there, but it doesn't fit. You're making the fish argument. You're saying it fits the elements, but it shouldn't fit the elements because it's a different kind, character, et cetera. That is, I just want to, again,
Yeah.
I'm just trying to understand because that is a different argument.
We think it's boiled down to its essence. There is no trafficking here. That's our argument. That's the argument that was made in the trial court, and that's the argument we're advancing. Of course, even if the argument has been developed more robustly here in the briefing and in the argument before the court here today, even if the argument has shifted slightly, I still think that if the person has not committed the crime that was charged, you have an affirmative obligation to say that, wait a second, this is fundamental error. The statute doesn't meet these facts. Line prosecutors don't charge human trafficking in cases of simple prostitution. It's just not what the statute was meant to cover. And so if you agree with our argument, then don't decide it on preservation grounds. Decide it on the fact that he hasn't committed the crime that was covered by this statute. So we think either way, and you know what, if I didn't preserve it as an appellate attorney or trial counsel didn't preserve it as a trial counsel, it's still going to come back up in a 3.850 motion. So decide it now or decide it later, it's up to you. I would urge the court to decide it here and now today, and if we're wrong, explain why we're wrong in a written opinion, and perhaps we can seek either petition for writ of certiorari in the United States Supreme Court, or we can seek conflict. Well, there is no conflict, I don't guess, because it's just Matos, but we would like to seek further review in the Florida Supreme Court because we don't think that this conduct is covered by this particular statute. And even if the literal terms of the definition of human trafficking, again, we're not conceding that these could cover it because of the reasons in Yates and in Dubin. We don't think that it covers it because you don't look in like Amelia Bedelia fashion to the broadest possible way that a statute could be read. You have to kind of, like they did in Yates, kind of restrict your analysis to what the statute is meant to address. But even if the statute could cover it, then we're into due process problems because a prosecutor can take, a statute, a second-degree misdemeanor in soliciting prostitution and charge it as a first-degree felony under the statute on the whim or caprice, or maybe the prosecutor's having a bad day. I mean, there are serious due process problems with that formulation, and we would hope that the court would take that into consideration. So there's the due process problems over here with regard to the void for vagueness doctrine. We also have due process problems with respect to the vindictive prosecution. And you know what? I mean, it couldn't be more clear from the record. He was given an ultimatum. You either forfeit your rights to a trial by jury, or else we're going to charge you with a life felony, even though we could live with an 8-year sentence. We're fine. We offer you 8 years. That's fine. But if you don't, submit to our will here and take this plea deal today, we're putting it on record. We're going to charge you with the life felony. And so I don't think that there could be any clearer. My friend on the other side, he makes the point, well, we could have charged it that way at first. Well, the difference does make a difference, or the distinction there does make a difference, because when you put it on the record, the reason why we're charging you with the life felony is because you're refusing to accept a plea. I mean, they said the quiet part out loud there. That is vindictiveness. There is a due process problem there. There's a due process problem with the void for vagueness issue, and this court can sidestep those due process problems by simply taking the most natural reading of the statute, and like it says in the first paragraph, the legislature finds that victims of human trafficking are subjected to force, fraud, or coercion. We're just asking the court to read that language and import it into the provision of human trafficking where it says, for the exploitation of the person. So exploiting by way of force, fraud, or coercion. So in the same way that like Staples and some of these Supreme Court cases where they sidestep due process problems by narrowing the definition that's at issue and kind of including the mens rea component to it, meaning that you intended to use force, fraud, or coercion for the purposes of trafficking this individual. Your Honors, there's no trafficking here. I'll reserve the remainder of my time.
Right,
Thank
sir.
you.
Thank you very much. Mr. Bradford.
Good morning, Your Honors. My name is Robert Bradford. I represent the state of Florida in this matter. I just wanted to start with vindictiveness briefly. The McClover case, which talks about the test for vindictiveness, cites U.S. v. Goodwin, in which the evolution of this line of law is traced all the way up to the Hayes case, in which the United States Supreme Court said almost 50 years ago that a prosecutor can come back and use an HFO sentencing enhancement after that defendant has declined its plea offer. Basically what the Hayes court said was that a prosecutor can use whatever leverage he has, period. It doesn't matter what chronology it comes in. It's simply they have the leverage. If they can use it, they can use it, period, end of story. With respect to issues 1 and 3, I think they're enough related. I'd just like to address them briefly together. I'll start with the Yates and the Dubin case. Neither case has anything to do with this, and there are several reasons why. First of all, they both involve statutory interpretation of federal statutes not using the Constitution, so therefore it's a complete matter within federal law and has no bearing on state law. Mr. Ford was prosecuted under a criminal offense in the state of Florida. Another reason is under the Machutka case, and I apologize for my pronunciation there. The Florida legislature, absent any constitutional infringement, has the power and the right to define state of criminal offenses in any manner it sees fit. It also has the manner to prescribe the punishment for those offenses, again, absent any constitutional infringements, in any manner it sees fit. There is no constitutional issue with this. This is a complete matter of the Florida legislature defining human trafficking to include an adult using or trying to use a child prostitute. They had the right to do that, and more specifically, Yates and Dubin have to deal with the use of generic words to prosecute in a manner not contemplated by the statute or by Congress in that particular case. In this case, that is exactly what is contemplated by the Florida legislature when they enacted this statute, because that's how they defined it. They specifically and expressly in the statute included an adult who tries to use a child prostitute as a human trafficker. That the appellant doesn't want to recognize his role in this industry by twisting the words of the legislature is of no moment. We can talk about which came first, the chicken or the egg. I mean, is the supply side there because did they create the industry, or did the demand create it? Generally, the demand creates industry, just a normal business principle. So therefore, when the legislature decided to combat this industry on both ends, it had every right to do so. The analogy to drug trafficking, I think, bears into that same argument in the sense that the Florida legislature chose not to include street-level, small-amount buyers of narcotics in the trafficking statute. But as I think the court pointed out, even if a regular buyer, just a consumer of drugs, buying for his own personal use, let's say, if he is buying an amount defined as trafficking under the statute, he is a trafficker, period, end of story. My friend raised an issue of possible fear of a due process violation when prosecutors prosecute the buyers of prostitutes as human traffickers. First of all, that entire argument is pretty much a red herring because, first of all, there's no right to hire a prostitute in the state of Florida. And secondly, and we'll set aside for the moment whether an adult prostitute ever actually voluntarily consents, even if she's being paid. But in this particular case, the human trafficking statute does not make the solicitation of the hiring of an adult prostitute by an adult without more. It's not trafficking. There's a whole laundry list of things, and the state has to prove additional facts for each one of those. And none of them, under no circumstances, can the state of Florida charge somebody with human trafficking when they purchased or tried to purchase an adult prostitute without more facts. The buyer has to use coercion, there has to be transport, they have to bring them in from out of state, something along those lines. There has to be just more facts that we'd approve. And I'll finish up because I honestly, I think everything here has been covered. With respect to the JOA argument and then the first issue, I do think it's a preservation issue that should control the day. Under the Murray case cited by appellant in the reply brief, while I agree that there are no magic words, in that particular case, the trial counsel had sufficiently specified to the court what issue they were going on, and they challenged, I think he specifically said DNA, there was nothing linking that defendant to the scene, and so he was arguing identity of the defendant, and he just never said identity, and the court said, no, it's close enough, he got close enough. The court below knew what he was talking about. In this particular case, I don't see human trafficking can in no reasonable way be interpreted to mean there's no human and there's no force, fraud, or coercion. So neither one of those arguments is preserved. And specifically under the Rodriguez case, also cited by the defense, by appellant, in Rodriguez, that was a JOA case, and the Rodriguez court held that to preserve a JOA argument, you have to specifically identify the particular element that you're challenging, that you're saying the state did not prove or did not satisfy. And that simply was not done here. So, and as far as the vagueness argument, it was also not raised at trial. At trial, the only constitutional argument was that the lack of a human constituted cruel and unusual punishment. So that wasn't preserved either. But strictly, and with due respect to opposing counsel, the void for vagueness argument, he writes it down in a as applied scenario. It's really not, because the argument he makes that it doesn't tell people who hire prostitutes that they're human traffickers. First of all, that's not the facts of this case, and secondly, it's more of a on its face argument because it applies to everybody, not just him. As applied would be to him, and to him would be child prostitutes, and of course that argument doesn't work because that's how the legislature chose to define it. So, unless the court has any questions for me, I will rely on my brief for any additional argument and issues and ask the court to affirm the judgment and conviction in all respects.
Thank you, sir. Mr. Greenlee, you have just over 5 minutes.
Thank you, Your Honor. Briefly on the vindictive prosecution argument, the case my friend was citing to, of course, if somebody is already subject to a HFO as a habitual felony offender, yes, you know, that he is subject to that. There's no dispute about that. We do dispute that my client was subject to human trafficking. The notion that you can use any leverage however you want to use it, not true. If you have vindictive intent, if you're actually acting with actual vindictive intent, that's unconstitutional. That's a due process problem. With respect to the statutory interpretation, of course, Yates and Dubin, they don't relate specifically to human trafficking, but the principles articulated are applicable here. Yates, it was a record-keeping case. So we're not going to have a fish that's a tangible object. Yes, it meets the actual definition set forth in the statute. My friend says that, you know, the Florida legislature can write whatever it wants in a statute. Fair enough. But we're here to determine what the scope of that criminal statute, what conduct is covered under that criminal statute. And so as a matter of statutory interpretation, we do look to the context, not the nascitura associus principle kind of directs us to look at what's covered. What is the purpose of the statute? In Yates, it was record keeping. In Dubin, it was aggravated identity theft. Here, it's human trafficking. Again, slavery, enslaving individuals, not consensual prostitution. I heard my friend say that demand, well, the statute seeks to get at demand. Well, if that's the case, then ordinary prostitution covering, why could they not subject adults to that? If you look at the definition of the statute, there's nothing that would prevent an adult being charged. The statute says it does apply to adults. In the first paragraph of the statute, it says it applies to adults. So there's no, there's no real reason why you couldn't charge simple solicitation of a prostitute between two consenting adults. Now, I take my friend's point that maybe a prostitute can consent, maybe a prostitute can't consent. But I could conceive of circumstances where a prostitute is consenting, the person who's procuring the services is consenting as well. Are we going to call that human trafficking? I think not. I don't think anybody in this courtroom would say that's human trafficking. My friend says, well, why can't you charge that? He says, well, there's other things in the case of an adult that you have to prove. I think he said coercion is one of them. Well, it sounds like we agree. If coercion is at the heart of this statute, forced fraud or coercion, like I'm advocating for, then you would have to prove that somebody intended that forced fraud or coercion be used. And there was no evidence of that. No evidence at any point in the trial. So, as much as my friend would like to say that the statute wouldn't apply in instances of ordinary, prostitution between adults, nothing in the statute prohibits it, and that is kind of the crux of our due process void for vagueness problem. The prosecutor, if they're having a bad day, if they don't like the way somebody looks on a particular day, somebody wears their hair long instead of short, you can charge them with human trafficking when all they've done is engage the services of the prostitute. So there are due process problems there, both on the vindictive prosecution side as well as on the void for vagueness side. And it is as applied to my client because the facts of this case are 10,000 miles away from human trafficking. He's not trafficking anybody in the ordinary sense that we use the word trafficking. He just showed up at a location. If there are no further questions from the court, I've said all that I came to say. Thank you, Your Honors.
All right, sir, thank you very much. Gentlemen, we appreciate well-prepared, well-presented arguments. And with that conclusion, we will stand in recess.